Welcome everyone. Good morning, good morning, good morning. Today's session is on contracts. If you've attended this session with us before, I'm going to go ahead and share a couple things that do exist in the Education Committee or GBBR. So while I'm doing this, let me probably see whether I can get your feedback from who's on video with me. So Katrina, can you see my screen? Either nod your head or speak. Are you seeing GBBR Education Committee? Okay, thank you so much. Stay on video. It's good for me to see a face when I'm talking. So thank you for being on video. My name is Brenda Kasuva. I am currently actually doing this class from GBBR because I am doing a face-to-face class at GBBR later on fair housing. I am the chairperson to the education committee, and all that means to you is that I volunteer, and part of the volunteering is my passion in education. So that's how I ended up being the chairperson for the education committee. I teach a lot. I teach the licensing class, I teach the CE classes, and also the designation classes. It would be nice to connect with you on social media. Just search for Brenda Kasuva. Part of your membership at GBBR is that we do have the face-to-face classes. So right now, if you feel comfortable that you want to come into the building, those are happening. They are spread out. Maximum is, I think, 20 people per class. But if you don't feel comfortable with that, I just wanted to point your attention that we do have online CE. And on top of online CE, we have these virtual classes. Right now, we have 3 left. There's this one today. And then we have another one on Friday and 2 next week. So I just wanted to remind you where you're able to find a list of all the classes that GBBR has is on their website. If you go to the calendar, it's mapped out there. When you click on the class, the virtual ones, you will normally see a link there for you to be able to register. That's how you found me. And we hope that you're able to join the remaining 2. This morning, we actually did have an education committee meeting, and we are now looking to add on and do these sessions well beyond the day we shall ever feel comfortable or able to come out to GBBR. We're still going to continue doing the virtual ones. So I'm going to pull kind of like a, I don't know what to call it. I'm going to challenge us, anyone that's attending with us today, if you have a topic that you would like to offer to the members virtually, please reach out to me. And at the end, I'm going to put my contact information again. What we're doing right now is gathering feedback from the membership week. We got a list of classes that people want. However, we do need people who are willing to teach the classes. So I'm challenging us, if you have a topic that you feel will be beneficial to your colleagues, reach out to me. We're able to schedule them. We shall be doing them on Zoom. Usually they're an hour, and we're trying to be consistent to where we offer them twice a month or once a week. We're still working that out. So reach out to me if you have a class that you would like to teach. The next session on Friday is virtual buyer consultation. Ebony is going to be doing that one. And then, as I mentioned, the remaining 2 next week are going to be 2 lenders who are taking us through mortgage lending, and then Brian Sachs is going to finish with a very interesting topic as well. Beyond July 17th, I'll ask for your patience because we're trying to map it out. We shall be promoting them and letting you know. Part of your real estate license is to take continuing education. So real quick, if you want to review the CE classes, we know we need 15 hours every 2 years. Legislative update, code of ethics, 3 hours. fair housing 1.5, brokerage relationship or agency. This is one of those, just as a shout out. A lot of us are looking for the agency class. The agency class name changed October 1st, 2019. So what you should be looking for is brokerage relationship. It's the same content, so to speak, with a little bit more focus on that this relationship is between the broker and the client. So that's part of your continuing education. And then we have electives for the broker in the meeting or the team leader or manager. You know, you would need supervision. Why do I bring this up? Is because some of us are not comfortable to come to GBBR. Please note that you can always take the classes online. That has always been available. It is on demand. You start and stop at your own pace. You can finish the 3-hour session in an hour if that's how short it takes you. These are the classes that are offered. It's not only the mandatory ones, they also have a lot of good electives that you might not find when you're taking them face to face. So for example, we're getting a lot of interest on people wanting the course on short sales and foreclosures. They have that there. Even though it takes, say, 6 hours, you could finish that in 2 hours, 3 hours, or 4 or 8 hours. They're all on demand. You start and stop when you are able to. Virtually, another thing that I want to also point out is professional development. So professional development are classes that don't count as CE, but you can enhance your skills. So those of us who mentioned that you have been in this for, let's say, less than a year, you're looking to learn as much as possible, please check out what is available. And the cost is this, which is going to continue until whenever we feel that people probably are looking elsewhere and coming face to face. So that cost is right now reduced to allow us to take advantage of all that is available. So now I'm going to get started. Unless there are questions so far, I hope you now know that online CE is available and professional development. I'm going to switch over to now talk about why you're here. And while I am doing this, let me do my other part. Sorry, things are moving slow on this side. It's always a little, I don't know why it's quicker or easier for me when I'm at home. I guess because I'm comfortable at home. But on chat, I'm going to put in my contact information so that if I sparked some interest to anyone who wants to conduct classes for us, this will be my cell phone number. You can text or you can email me with whatever topic that you think you are able to teach, or let me give you an incentive if there's a topic that you feel that we need to find people to teach. I'm open to take that as well. So I'm sharing my contact information. I think that's right. Okay. I'm switching over to contracts, and Katrina, you're gonna guide me. Let's see. So Katrina, share with me. Are you seeing today's overview residential sales contract? Thank you, my dear. We are going to go through the sales contract. First off, I want to point out that the sales contract that we normally see has the logo of Maryland Realtors. Point of reference is that we have 47,000 of us in the state of Maryland that have a real estate license. About 27,000 of us are realtors, meaning they're members of GBBR or any of the other 14 associations in the state of Maryland. The remaining 20,000 are not members of Maryland Realtors. Why do you care? Is because when that person is presenting you a sales contract, it might look a little bit different than what you're used to. It's still okay. as long as they meet all the requirements that are needed in a contract, it is still a valid contract. So it doesn't have to have the Maryland Realtors logo at the top, just point of reference. So where do you find all the forms? I'm going to point your attention when you're looking for forms. The first part is to check with your broker. Most brokers have an online contracts program that they use, whether it's .loop, Zip Forms, DocuSign, or what's the other one? Yeah, Zip Form, DocuSign, AuthentiSign for people to digitally sign it, or .loop. You will find the forms there. Brokers are supposed to be getting the information from all the different resources. Sometimes they might not be updated, to be candid. So this is where you're able to get all of your forms. If you go to marylandrealtor.org, if your broker doesn't have it, or if your broker doesn't have a contracts program, this is where you're able to get all the forms. So they will have the state ones. They will also have the GBBR forms are also going to be found there for Baltimore County and Baltimore City and all the other pockets that you might be doing business. So let's get some engagement in chat. Read the question first and then let me know what you think your answer is. Is this a true statement or a false statement? So true or false? Your buyers have put in an offer, it has been accepted. So the parties have executed a contract, meaning buyers and sellers have signed everywhere that needs to be signed in this particular contract. Your buyer did not include a deposit. Is this, or rather the sentence is, this is not a valid contract. True or false? So this is not a valid contract because it does not include deposit. Is that a true statement or a false statement? Let me move my stuff up a little bit. Somebody is already participating. Shanita, thank you for your answer. Katrina, Shanika, Mary, thank you for your engagement. Tara, thank you. So let's see. Yes, this is false, right? Because you do not need a deposit for you to buy the house or for you, the seller, to sell the house. Yes, it's expected, but it is not required. Consideration in a contract would be what? The money, right? Or something of value. For us to say that we have a contract, we just need, did somebody make an offer? Did somebody accept it? Does the other side know that it was accepted, which is delivery? And then consideration is normally going to be money or something of value. It could be that I am selling my house to my daughter. I'm not going to charge her. So my consideration is what? Love and affection, because I'm selling it to my daughter. It has to be legal and have consent and competent parties. So consent is just sound mind, and competent parties is that we're assuming that everyone is over 18. So offer and acceptance, meeting of the minds. Consideration is anything of value to you. Most of us value money, but it could be love and affection or an action. It's legal. Now this one I pause a little bit because when you're putting in an offer, we make sure that it's legal. How? Buyer's agents and seller's agent public notice announcement is that we do need to be looking at the deed. Please do not assume that the listing agent checked, because here's a good example. And this one I'm not discriminating based on gender. She calls the agent and says, hey, we're thinking about selling our house. Agent asks, what have you done to your property? And the lady gives all the information about the property and shares that, you know, my husband and I have been living here. This is my husband's name. Agent will go ahead and do what? Put both names on the listing agreement so that when the agent is going for the listing presentation, they're ready. Listing agent never checks the deed to confirm that what? She, the lady, is on the deed. And this has happened to me where, again, you assumed that it's because the lady that called and she knows about the house that she's on the deed. Well, the guy never put her on the deed. He promised he was going to, he never did. So now we don't have a valid contract because technically the woman should not be signing this agreement because she doesn't own the house. So this is where it could be illegal. The person who's signing the documents has to be the person who's on the deed. Now, buyers agents, I do a lot more buyers than sellers. We also need to check because you don't want to assume again that the listing agent did their part. And on top of that, what are you getting on the deed is if there's a condo association, if there's a homeowners association, and probably the bigger topic, since it was done last week, would be what? The ground rent. So we're double checking to see that information. That's why you go to check up the deed. And I pause here. If you're not familiar with where to check up the deed, and usually I have my notes posted, Maryland Land of Records, and I'm just quickly typing in the website. Usually I do have somebody helping me with this part to type in all this information for us. Today we're gonna be fine. That's the website that you're able to go to search that information in terms of the deed. It's a public website and you're able to get access to the deed and any of the deed of trust and or the mortgages. We assume everyone is over 18 and we assume everyone is of sound mind that is getting into the contract. It needs to be in writing. Please hear another public service announcement. Everything needs to be in writing. I have experienced where the buyer wants to move in the stuff because settlement is going to happen on Monday. So buyer asks, hey Brenda, can we check with the seller whether we can move in our big stuff over the weekend because we have family helping us move this stuff? And we say sure, because we contacted the listing agent and seller said, yeah, sure, why not? We're settling on Monday. Well, come Monday, some of us have experienced this. What happens? The buyer doesn't get the property because something came up, and now we have to move settlement to Tuesday, or we now have to move it to Wednesday, or it's not happening at all because something came up and we're not able to get to settlement. Now what do? The things have already been moved in. There was never really an agreement in writing saying that the seller is okay. This was just a verbal conversation or it was put in an email. Now what do? This is where your manager comes into play. Brenda is just presenting a scenario as to why things need to be in writing in order for them to be enforceable. Okay, how am I doing so far, Katrina? Do you have a question for me? I know I'm picking on you because I like looking at someone. None? Okay, so let me see how I'm going to quickly go through. I'm making sure that I'm going through the highlights. So if there's any question that you might have on the sales contract part, please let me know. I know I haven't even started looking at it yet. Right now, we're just covering the basics. Let's talk about the deposit because this is something that is on your contract. So with the deposit, couple things that I'm going to talk about with the deposit. One, a lot more brokers are not holding the deposit. So if the broker is not holding the deposit, please make sure that you include a document. This is an example, a document that's pretty much going to say who's holding the deposit. So Maryland Realtors has one. Escrow agreement between the buyer. It talks about which title company is going to be holding it, how soon the deposit needs to be deposited into the bank account, what happens if the money is not in the bank account, and then what are they going to be able to do if things don't get to settlement. So this form all addresses that. It needs to be signed by both buyer and seller, acknowledging that, and then it also needs to be filled out by the title company. Now let's talk about what happens when things don't work out. So we all know that sometimes things don't work out. Here, just in review, we need to make sure that the two documents are signed. There's one for mutual release of the contract, and this is what it looks like. All this form is talking about is saying, Brenda, you're no longer responsible to buy this house. Katrina, you're no longer responsible to sell this house. The money part of it, the deposit part of it, is handled separately. In order for Katrina to get to keep the deposit as the seller, buyer needs to sign off on that. In order for Brenda, the buyer, to get the deposit back, then we need to sign off on that. And that is something that is hopefully mentioned when you're going through the contract. It's on page 4, paragraph 20. It's all addressed there, what is supposed to happen to the deposit. So this is where you have that moment of pause. Buyer, you're buying this house, $3,000 is being collected. If things don't work out, then this is what is going to happen. You would need to sign a form saying that you want the money, or sometimes it's your fault, buyer, therefore the seller is going to be keeping the deposit. The money cannot come out of the account, Miss Buyer, unless that form has been signed, or we go to court, or if it's being held by the broker, then there's a 30-day letter that the broker is able to submit. And then this is a release. Hopefully you've seen it. If not, you're able to find it in the Maryland Realtors website. Since we're talking about deposit, let's check in with you. The deposit is $3,500. Buyer wants it to get interest. Can it? True or false? Your buyer is putting a deposit of $3,000. They want it to get interest. So this is for those of us who are joining us. We're putting our answers in the chat box just for engagement. If you've never done the chat box before, it is found by clicking on More or Participants, and then you type in your answer. So Mary's saying no interest. Katrina is saying no interest. How about the rest of you? Do you think it can? Can it gain interest? Thank you, Kelly. Kelly's saying it's an option. Awesome. You've been reading. Yes. Okay. The rest of you, we're going to find out. Yes, it can. It's an option, as Kelly put it. So this is where I say, buyer, yes, it can. Here's what you need to know. And I'm still getting people joining us. Thank you, Shanita, for your answer. You think it can? Yes, it can. This is where you tell the buyer, if you wanted to get interest, right here on the paragraph 7 of your sales contract, which talks about who's holding the deposit, how much is it, and also gets into, can it get interest? So this is where you have that verbiage here. If buyer, you wanted to gain interest, you can. However, you need to pay the broker to set up an account where this money is going to gain interest. And here, Miss Buyer, let's weigh it out. If you're going to pay $30, $40, $50 for this account to be set up, your deposit is $3,500. The interest that you're getting from the time you give this deposit to the time we get to settlement, are you really going to make any interest after paying the cost to set it up? Then that's where most buyers will say, okay, that's fine. I was just curious. But I have experienced when somebody was buying a new construction, because it took about 9 months, and for them, they felt it was worth it, because for the new construction, it was about $10,000 that they were putting down as a deposit. So yes, buyer, it can. However, you do need to pay for it. One more interaction. The couple people that have joined us, if you're joining us, we are putting our answers to the question that is presented to you on chat, which is found by clicking on More, and then you click Chat, or you click on Participants and you click on Chat. Here's the next one that always comes up. Your buyer is a first-time Maryland home buyer. They've never bought a house in Maryland before. Do we need to include the first-time home buyer addendum in order for the transfer taxes to be split? So I'll read it again. The buyer is a first-time home buyer, the first-time Maryland home buyer. The parties wish to split the cost evenly. Do we need to have the first-time Maryland home buyer addendum? So this is a false. You don't need it. You don't need it. And I know I missed checking out your answers. Nope. Kelly, you're good. Yes, thank you. So Kelly's good. Yes, you do not need it. If the costs are being split evenly, then in your contract, paragraph 24 and 25 addresses that. Paragraph 24 talks about buyer. You're going to be paying closing costs. 25, when we get to the recording taxes and the transfer taxes, they are going to be split evenly unless negotiated otherwise. What is unless? My two examples, anyone who has more examples, please share. One is they're buying new construction. 98% of my experience when the buyer was buying new construction, the builder passes on the cost to the buyer. So the buyer at that point was not going to split evenly between the builder, the seller, and the buyer. That is the unless negotiated otherwise. The other unless, which to me it's not really a choice, is when the buyer is buying a foreclosure that's by the government entities. The Fannie Mae, the Freddie Mac, or HUD. Those governmental entities are exempt from paying transfer taxes, therefore it shall not be split evenly. So that's the only time that I have experienced that. So in that case, we shall include the first-time Maryland homebuyer addendum and say the buyer is paying it all. Otherwise, 99% of the other scenarios, you do not need to include that addendum. The contract itself already addresses that. Now, we'll address that sometimes it's a grant program and they're asking for it. This is where I say, what's the harm? Sometimes it's somebody who's asking for it, then I just give it to them after educating them that they don't need it. You do not need it. You just need to check off the box as Kelly mentioned. Thank you. So the usually deposits are what we need to cover up front, and then we also have the first-time Maryland home buyer addendum. Let's see. I want to make sure that I'm covering the top topics. So this addendum, the Maryland first-time home buyer addendum, is only needed if it is being split differently. Counting of days is the next thing that always comes up. Counting of days. What is the first day, or rather, when does the clock start ticking? Ticking to me means, is it from the time you got the documents? So let me present it this way. The contract was accepted. You received a copy of the contract. Is day one today, when I received it at 12:03 p.m., or do we start tomorrow? What is the first day to start counting in order to follow the time is of the essence clause? This is another opportunity for you to chat. Oh, Kelly, nice. I need to go back and check how long this lady has been licensed. Thank you, Kelly. Mary and Kelly, you're correct. The day after. So if I got it today, if I got it being the sales contract that has been signed by everyone, or rather both parties have signed it, and I got it today at 6 o'clock in the morning, or I got it today at 11:45 p.m., day one is tomorrow. If you count today, that's fine. Don't panic. Technically, the day starts tomorrow, and hopefully we know what? We know that all the days count, And to me, all means it doesn't matter whether it's a holiday or not. And lastly, it also means that we are using the Eastern Standard Time, so just be aware of that. Where do I get this information? Right in the contract. Paragraph number 58 mentions that. So it starts the following day is what you're seeing here. And it also makes sure that you know it is standard time. Okay, let's see. I got a little bit of feedback. Let me see what you presented for me. Yes, Mary, thank you for that. I will stress upon that. Remember that the other side needs to be aware of it. So Mary is reminding us about delivery. So once everything is signed, delivery is still needed. The other side needs to know about it. So delivery still needs to occur. Thank you, Mary. Yes, it does. So now let me call out a couple things that probably are, what am I going to call them? Stress points for your manager or your team leader, or probably for yourself. Of the 11 pages, and this is my moment where I'm just going to go directly to the sales contract for us to look at it. So bear with me. Your screen is going to shift a little bit. I'm still on, and I'm going to continue talking till I open the document. What I'm opening right now is a sales contract for us to spend the next 30 minutes or so going through a couple of things on it. This will be a good opportunity for you in case I haven't answered a question that you might have. Please share it on the chat. And while I am shifting over, I'm also going to be presenting to you what are the new forms that have come up as of October 1st or January the 1st. Usually Maryland Realtors is going to be updating their forms. Usually they're effective either, this is the one time that I've seen where they changed it to January, and it was because of the non-resident sales tax being going up, and usually they do it in October. So now I'm going to come back to where you're going to see my screen. So my buddy, let me know whether you can see it. You see it? No, wait, you're not seeing it. Now you should be. So let me know. Katrina, you seeing the contract? No? Huh, okay. Let's try this again. How about now? Yes, okay, thank you. So the sales contract, thank you. I think someone put it on chat. Thank you for letting me know that you can see it. Thank you, Shanika, so much. With the sales contract, 2 documents that I want to bring to your attention if you haven't seen them already. One is this document probably eliminates the use for us to use the blank addendum. The blank addendum has been there for so long. It is a pain to walk you through the blank document, blank addendum, because there are 3 schools of thought. One is, Brenda, you're not a lawyer, you shouldn't be putting words in there. 2, but Brenda, it exists, so can I at least try, come up with what is it that we want to do? And then the 3rd school of thought is, okay, if you're going to use it, then these are your 3 options. One lawyer will say, give it to the buyer and the seller for them to write out what they want. Another attorney has said, the less you put there, the better. And another attorney has said, the more you put there, the better. So this is why Brenda will not use the blank addendum, and Maryland Realtors did a good job last year of creating a document that solves that issue, because most of the times the things that go in there could be addressed in this document. So the change in terms, it addresses 4 things that are the top 4 topics that go in the blank addendum. One is, are you changing the price? because it didn't appraise and now we have to come down, or it what's the word I'm looking for? It overappraised, I guess is a word. It went over the sales price and now the buyer wants the seller to give them contribution, so the purchase price is changing. You have that option. Settlement date, probably it's the most common one. So you would just make your changes there. The financing contingency has changed because now you're no longer settling on Wednesday, it's gonna be Friday, and or they switch from FHA to conventional. This is where you're going to be making that, and then other. So this is the document that probably should be now in your library if you haven't used it already. So the sales contract. There are a couple of paragraphs that I like highlighting because I see questions on it. As I'm scrolling down, I'm going to start annotating and call out some of them. Estate is where you're going to be filling out whether it's fee simple or not. This is where you're doing your homework. You're checking with the seller and you're checking the deed to confirm whether it has ground rent or not. Believe you me, if you attended last week's session on ground rent, we have had experiences where the listing agent didn't check that there was ground rent, advertised it as fee simple. Buyer's agent knew that there was ground rent, did not tell the listing agent. Some will argue they should have, some will argue it's not their job. I'm gonna leave it there. We get to settlement and the title company obviously has told the seller gets upset and seller says what? Hey, you listing agent, you should have done your job. So guess who ended up paying $3,000 on ground rent? The listing agent. So this is one of those. Both sides should be checking on the deed because some of us have probably paid on that ground rent bill. Payment terms, we already spoke about ground rent. Let me see, I'm not covering everything. I'm just summarizing a couple things. Settlement date, please. This is a date. So a date is what? July the 8th. It cannot be to be determined. It cannot be TBD. It cannot be 30 days after short sale approval. It cannot be 30 days after appraisal. It needs to be a date. You can always settle sooner, and you can always use that form that I just shared, change in terms. If the date does not work out, you can always make the changes on this particular document. We have financing. You're checking whatever is applicable at the moment because you've done what? You've contacted the lender and you've confirmed what it is that the buyer is going to be using. This is another moment of probably, let's get along. Please note that the listing agent has every right to call your buyer's lender and find out as much as they can to make sure that we get to settlement. We have experienced where the buyer's agent is upset because the listing agent called the lender. It's their right for them to do so because they're looking out for the seller's interest. Please note that the lender is smart enough not to share confidential information about your buyer. So just be aware of that. And if you're a listing agent, if you haven't been calling the lender, please start to do so. That's one of those things that you're trying to make sure that you get to settlement. And then you are also have the box other. When would you be using the box other? Or when have you used it? Let me ask the group. You can either chat or speak to me. Has anyone used it? Okay, Mary say that she used it for cash. Shanika, what did you use it for? Shanita used it for cash, okay. Well, I guess I had money lender. So other is the opportunity for you to use it for these scenarios that you're hearing from the group. Yes, yeah, Shanika, you brought a valid point, which is what I'm going to present. you are able to use it for cash. However, this is where you always have two schools of thought. Some people will say, Brenda, when it's cash, then maybe I will select no financing contingency. That's fine. For those of you who've been using other and you type in cash, that's also fine. Here, I'm just presenting both sides. Usually, if it's cash, sometimes the person wants an appraisal, sometimes they don't care. So that's why you have those two options to where if it's cash, no financing contingency, they don't care about, what is it called, appraisal, then that could be no financing contingency. Sometimes when it's a hard money lender, then you might want to be putting that information under other. Another option for other is when the buyer is using a program. Program meaning it's a program that's going to be helping them with their closing cost. You do need to let the sellers know of that information. So this is where if my buyer is getting a conventional loan and they're doing a program that's helping them with closing cost, I'm going to put it under other. I'm also going to ask the lender to put it in the pre-approval letter. This is now a Brenda thing. I, Brenda, will also call the listing agent and educate them a little bit about this particular program so that they get to understand that I am familiar with the process so that they're not telling their sellers, oh no, I experienced this program and it did not work out. So sometimes you have to educate the other side in order for you to stand out, so to speak, and in terms of the seller being comfortable in picking that particular offer with a program. I'll only cover probably 5 more unless I get more requests. One is going to be, so this is my number 1 in terms of the 5, is the financing contingency. This part, or rather, sorry, financing application. These days here, and I have seen it, cannot be the same number. And here's why. Here you cannot have 7 and then here 7 as well, because this first one is for what? Written application. How many days does a buyer have to do an application with the lender? 7. And 7 is just a number. Yours could be 3, it could be 5, it could be 12, it could be 10, it could be 1. This is all negotiable between the buyers and the sellers. The less the number, the better for the seller because they want to make sure that we are moving forward. The other number is going to be what? Financing commitment. So financing commitment is where we are saying what? The bank has vetted the buyer, checked their credit, checked their income, done an appraisal, and now the underwriter is just looking at final things. This is where the bank is saying, I am 90% sure that I, bank, I'm going to give money to this buyer. So the financing commitment is probably going to be closer to the closing date. So what I do, Brenda's practice, is if I have settlement and it's a 30-day settlement and the buyer is going to be getting financing, then this second number is what, 25? So I always do 5 days before closing is how long we are hoping the lender is going to give us, yes, thinking about giving this buyer money. Most of the times, in my experience, buyer's agent has to call the lender and make sure we are good. Listing agent, you need to be calling the lender as well, because unfortunately, and if there's a lender in our conversation, they don't provide this document to us unless we request for it. So this is the responsibility or something that is left over for the buyer's agent and the listing agent. If it's a 45-day settlement, Brenda's practice is that it shall be 40 days. And sometimes I will still put 45 days as a financing commitment. Why? In case we have to extend the settlement date. Because if we extend the settlement date, the seller might say, no, I don't want to extend the settlement date because you do not meet your financing commitment days here. So here is just a lot of information thrown there is the days for application and financing commitment need to match what we're saying. The financing commitment days probably is a couple days before settlement or up to the day of settlement, whichever style you pick. If you end up changing your settlement date, this is just your manager hat that I'm wearing right now. If you end up changing your settlement date, you might as well also make sure that the financing contingency is taken care of as well, so that the seller doesn't call out on the buyer for not performing just based on the financing commitment part. Okay, guys, that's my number one. My number two is this comes up, and every time I teach a CE class, continuing education class, I bring this up and I always get different answers. So I'm gonna try it again. Inclusions. You saw the house, there's no washer dryer. Again, there's no washer dryer, nothing plugged in, and there's no box with a washer dryer in the property. Your buyer is saying, hey, I don't have the time to go searching for a washer dryer. I want one. So how would you ask for a washer dryer that does not exist in the property? Do you check off? So let me give you three options. Do you check off the box, washer, clothes, what is it called? Sorry, I shifted a little bit. Sorry, that wasn't my intention. Do you check off the box, clothes, dryer and washer? Do you type it in the inclusions, or do you include it in paragraph 18 under special conditions? Those are your three options. Let me see what you got for me. Okay, so Mary shares additional inclusions, Shanika as well, and Kelly as well. So hopefully now we know. If you did not answer the question either because you don't know, or you weren't sure, or you didn't want to be wrong, that's okay. So this would not be an option in terms of asking for it here. Some of us have done it. So this is where you as a listing agent need to be double checking as well what has been checked off before your seller signs off, because some people will say, well, we checked it off, therefore you need to provide it to us. And then this is where we just get into, let's look at the big picture and we try work it out. However, the contract says if we were going to go to a judge, and this is where we checked off washer dryer that did not exist, and we checked off the boxes, here's what we are saying. Whatever is included here is everything that is attached and now existing. So if it doesn't exist, we should not be checking the boxes. The best practice is to put it under additional inclusions, which is here, or if you go to paragraph 18, I went the wrong way. If you go to paragraph 18 under special conditions, include it there. My other 2 cents about asking for clothes dryer is, and washer, is share what is it that the buyer wants. Because if you say seller to provide a washer and dryer, guess what some sellers will do? They'll provide a stackable one, and that's not what your buyer thought they were getting. Or your seller will get a used one, a refurbished one, and that's not what your buyer expected. So you need to be as specific as possible. Get guidance from your manager or your team leader. The words full-size washer dryer, brand new is good for me, Brenda, but I'm not your manager, so please check in with them on that. So I think that was number 2. Number 3 is on paragraph 18, double check and make sure what is the final stand in terms of addenda? Because this is what has happened before. You started off the offer by asking for example, seller contribution. You checked off the box and you included the seller contribution addendum. Negotiations happen, seller contribution is no longer part of the offer. You took out that particular addendum, but you forgot to update this paragraph. So here it's still checked off. Now this might be no issue for you, but you know who might have an issue with it? Your underwriter. Some underwriters go check in this, and if they see this was checked, then they're going to say what? Where is the seller contribution form? Now we still are able to work it out to where you either send a document stating that there's no seller contribution. However, for me, put in the hat of your manager would be get it correct before it even gets to the lender. So when you're going back and forth and negotiating, always go back and double check on your paragraph 18. So that's number 3. Number 4, okay, I see a comment. Yes, you can. You can. So Mary said, yes, you can use the change in terms addendum to get that addressed. Yes, yes. I have experienced where the underwriter did not want that. And lucky me, so we just had to get a whole page, whatever that page it is, number 4, without that checked. And then buyers initialed everything. So yeah. There's always that going to be that one that doesn't want it done a certain way. What was I going to talk about? Oh yeah, the 22 is where it addresses how the property is going to be delivered. Unless it is sold as is, it's going to be delivered the way you saw it at that time. I wanted to talk about probably another one that comes up a lot. While I'm scrolling, let me know if you have questions. I'm trying to see how I'm going to introduce this. Well, let's talk about it. I'll probably end up with 2 more. We shall still end in time or on time. Mediation. This is a paragraph that has been updated, that if you haven't spent time reading it, I'm going to summarize it for you. This paragraph is talking about buyer and seller before you sue each other. By you signing this contract, the one provided by Maryland Realtors. Remember, if you're signing a different one, it might have something different. But if they're signing the one that is provided by Maryland Realtors, buyer and seller, you will give us the opportunity to mediate before you take each other to court. So mediation is where it's saying buyer and seller, before you sue each other, let's try to work it out. Mediation is the process first before you sue each other. You've been given that opportunity, however, there's a time frame. We need to do that within 1 year of the settlement date. So if something came up to where the buyer moved in and now they're upset that the seller didn't disclose something and now they want to sue, buyer, let's first try work it out, and we need to get that resolved hopefully within 1 year after the settlement date. You have 1 year. So that's something, I don't know if it comes up, but it's just something for you to be aware of if you get to that point. The other one I was going to finish up with is, and if there's one you've seen or you've heard of that you want to be clarified, please let me know. I haven't been seeing anything. This one is just going to be something that you plant at the corner of your brain somewhere, and why? Paragraph 54D. So 54D, it's in capital letters. We skim through it, and I wanted to bring it to your attention. Why? With COVID-19, I'm sure we can all see the signs. that there are probably going to be a lot of foreclosures next year or in 2 years. And there are also going to probably be an uptick in short sales. So this paragraph, this is a law, so it's in Maryland, which is pretty much going to state that if you present an offer and it's accepted, and the seller and the bank have an arrangement which allows the seller to continue living in the house. So in this scenario, seller is trying to sell their property, they're late on their mortgage, and maybe you know or you don't know. And seller accepts an offer. And seller contacts their bank and they now come up with a better deal to allow the seller to continue living in the property. Seller doesn't want to sell anymore. This law allows the seller to cancel that contract. So protection for homeowners and foreclosure notice is that if the seller has been late at least 60 days and after the date of contract acceptance, seller has a right to what? Rescind. If you don't remember what rescind says, is what? Cancel the contract 5 days after they have accepted it. So in the future, when short sales are now almost normal again and foreclosures are more, what I would be doing as a buyer's agent is to ask the listing agent, is this seller able to get paragraph 54D come into effect? And that's all I say. And then what do I normally get? The listing agent doesn't even know what I'm talking about. So this is where I'm just educating you that that is going to be probably more prevalent in the next 1 to 2 years. Last but not least, as we end, please do everyone a favor and fill out page 11. It's not only for your benefit, it's also for the benefit of the lender and the title company as well. When all of the information is filled out here, this is where they're able to get in touch with the people involved. That was it for me. Unless you have questions, we went over by a minute. Otherwise, hopefully we'll see you next week. Thank you for joining us and do have a great day. I hope you took something out of this. Take care, everyone. You are welcome. Thank you, Kelly, for being here. Thank you for your feedback. Shanika, thank you. Mary, you're welcome. And Kim and everyone else, thank you for being here. Cody, welcome. Thank you for being here. Hi, Miss Pullum. Thank you for being here. Have a good day.